Oahu Condos, what you need to know before buying. Aloha, my name is Duke Ong and I'm the principal broker at Blueprint Real Estate Advisors in Honolulu. In this video, I'm going to discuss what you need to know when buying a condo on Oahu. Before we do that, make sure to like, subscribe, and turn on notifications. If you have any questions about real estate, please reach out to me. I'll leave my contact info in the description below. 4. Common governance issues. Condo living in Hawaii can be great, but there are some things to think about as far as what's allowed and what's not. Every condo association has their own declaration, bylaws, and house rules which must be followed. What are some of the most common issues? One is smoking. Hawaii state law prohibits smoking in enclosed and partially enclosed spaces open to the public, including elevators, lobbies, and other common areas like hallways and stairways. This prohibition includes electronic smoking devices. What about smoking inside individual units? State laws do not prohibit it. However, some associations' bylaws do not allow smoking in individual units or on the property at all. It depends on the condo's governing documents, so be sure to check those. What's another common issue? Well, if you want to make modifications and changes to your unit, they must not jeopardize the soundness and safety of the property. To make additions or alterations that will not jeopardize the property, owners usually need to get written consent from other owners or the board. While you may be able to paint the interior of your unit any color you want, you may not be able to enclose your lanai without approval. These types of issues sometimes get complex, so it's best to review the governing documents to determine if approval is required before any work starts. Next is another important issue: parking. Parking stalls are in high demand at many condos. Unit owners may transfer or exchange their assigned stall to another owner only if the declaration allows it. These types of exchanges must be legally documented as an amendment and provided to the association. And our last issue is pets. Pets can be loved or hated. Your condo's bylaws will tell you if pets are allowed. If the bylaws do not specifically prohibit pets, the presumption is that pets are allowed. The bylaws may have restrictions regarding the size and number of pets and excessive noise. So the best thing to do is check your condo's bylaws. As you can see, everyone needs to cooperate and follow the rules to make condo living the best it can be. The philosophy of condo law is based on self-governance and self-enforcement by the owners with little government intervention. So, when disputes arise, the parties should first discuss the issues calmly, focusing on the facts. Simple misunderstandings can often be resolved quickly if each party openly communicates. And since these are your neighbors, it's important to resolve these disputes instead of letting them fester. If that doesn't work, there are several dispute resolution options available. They are mediation, arbitration, and litigation. Mediation is an informal, inexpensive, confidential way to resolve disputes. In mediation, the mediator acts as a neutral third party. There are two types of mediation: facilitative and evaluative. In facilitative mediation between the parties to help them understand each other's point of view and work out a solution. In evaluative mediation, the mediators are often attorneys or retired judges who are familiar with Hawaii condo law. This means they can evaluate and provide an assessment of each party's position. Just remember, the mediator does not decide who is right or wrong, but may provide insight as to who is more likely to prevail if the dispute goes to court. If the parties are willing to participate and want to reach a resolution, mediation will usually be a success. Mediation and arbitration are not the same thing. There are similarities but big differences as well. Like mediation, arbitration is a way to resolve disputes outside of court. The arbitrator, like the mediator, is an impartial third party. Unlike mediation, in an arbitration, the parties present their evidence to the arbitrator, who reviews it and issues a decision. This decision can be binding or non-binding on the parties. With voluntary binding arbitration, the parties are bound by the arbitrator's decision and must first participate in evaluative mediation. The cost for mediation and voluntary binding arbitration are subsidized by condo associations registered with the Real Estate Commission. The last alternatives for resolving a dispute are regular arbitration or civil litigation. These are usually the costliest, most time-consuming, and most contentious options. Going to court is expensive, and it sometimes takes years for cases to go to trial. Lawyers are often hired, and a judge or jury will make the final decision. The parties involved should think very carefully about choosing these methods because their adversarial nature can result in continued conflict between the parties. Remember, many disputes can be resolved by discussing the issues with a cool head rather than letting them get worse. 5. Governing documents. As a condo owner, you've probably heard of bylaws and house rules. We'll clarify and explain the key condo documents and why they're important. All condo associations are governed by 2 documents. Let's find out more about each of these. The 2 primary documents that govern condos are the Declaration and the bylaws. First, the Declaration is one of the legal documents that creates a condo. It includes legal descriptions of the condo project and each individual unit. It describes the allowable use of the units and the common and limited common areas. The Declaration also specifies what owners can and cannot do with their units. It spells out common elements such as lobbies, hallways, and amenities. The association's powers and obligations are also defined in the Declaration. The second primary document is the bylaws. They support the Declaration and provide the rules and regulations which set up how the condo is governed. Bylaws cover the voting rights of unit owners, board election procedures, and how often meetings must be held. They establish the number of board members, their qualifications, powers and duties, and terms of office. Bylaws can also address budgeting, maintenance fees, assessments, insurance coverage requirements, and whether pets are allowed. Next are the house rules. In addition to the Declaration and bylaws, some condos also have house rules. These rules govern the daily facets of condo life, like quiet hours, full hours, holiday decorations, and guest parking. They may prohibit residents from hanging their laundry over their balcony railings to dry, or limit the number of shoes and plants that can be kept at their door. The house rules may also set fines for rule violations, so unit owners, residents, and guests need to know and follow the rules to keep the condo running smoothly. As you can see, these documents are used to establish the framework for each condo. It's important for prospective owners to ask for an association's documents when they consider purchasing a condo. That's the time to make sure there aren't any deal breakers, because when you purchase a unit, you agree to comply with the rules and regulations in these documents. 6. Meetings. You've probably seen meeting notices posted at your condo, but not all meetings are the same. We'll talk about different types of meetings and why they are important. There are 3 types of condo meetings: association, board, and special association meetings. First, there are association meetings. These must be held at least once a year, so they're commonly known as annual meetings and are open to all members of the association. Owners may attend, but not tenants or guests. Notice of the meetings must be hand-delivered, sent by U.S. mail, or emailed if the owner prefers, at least 14 days before the meeting. The notice must state the date, time, and place of the meeting and agenda items. Barring a natural disaster, the meeting must be held in Hawaii. Association meetings must be conducted in accordance with the most recent edition of Robert's Rules of Order, newly revised, unless the Declaration or bylaws preclude it. The meetings may be conducted by any means that allows participation by all unit owners in any discussion or deliberation, including video or teleconference. Agenda items typically include important governance, maintenance, and financial matters, as well as board elections, officers' reports, rollover of surplus funds, and amendments to the governing documents. There must be a quorum or a minimum number of owners at the meeting, either in person or by proxy, for the association to take any action. The bylaws determine the number of owners required to constitute a quorum. Next, there are board meetings. They must be held at least once a year, though they're usually held more often. Notice of the meetings must be posted in prominent locations within the condo at least 72 hours before the meeting, and include the agenda items, unless the declaration or bylaws say otherwise. The meetings may be conducted by any means of communication through which all directors participating may hear each other. Board meetings are open to all members of the association except for executive sessions. These sessions are limited to directors to discuss and vote on certain matters such as personnel, association, litigation, and contract negotiation. Directors cannot vote on any issue before the board in which they have a conflict of interest and must disclose the conflict prior to any vote. Board meetings must also be conducted in accordance with the most recent edition of Robert's Rules of Order, newly revised. Finally, there are special association meetings. These may be called by the board president, a majority of the board, or a position to the secretary or managing agent signed by at least 25% of the unit owners. Special association meetings may be called to consider specific issues which require member approval, but cannot wait until the annual meeting. Again, there must be a quorum, a minimum number of owners present, either in person or by proxy, for the association to take any action. And these are the 3 types of condo meetings. Alright guys, that's it for part 2 in this 4-part series. Be sure to check out part 3 to continue learning more about Hawaii condos. If you enjoyed this video, make sure you leave a like, click the subscribe button, as well as the notification bell next to that to continue to learn more about real estate on Oahu. See you next time.